All right, it is Friday, August 1, 2025. Welcome to Borderlines, Canadian Immigration Law Podcast. I think it's been a while since I said what kind of podcast it is. Hopefully, as the episode goes on, it's obvious that that's what it's about, although maybe not, because today we're doing basically what will likely be a shorter than normal episode on just little Crimmigration updates, essentially on previous episodes that we've done on a variety of topics of the intersection of criminal law and immigration law. So we've pulled up from a few recent Supreme Court decisions to news stories in the year, several little just developments. Again, for those who have sometimes wondered why we talk about criminal law on the podcast, it's because both Deanna and my practice deals a fair bit with that intersection of criminal and immigration law, especially, at least in my practice, for foreign nationals or permanent residents who have criminal convictions, because it makes them inadmissible to Canada, which we can touch on in a bit. Before we dive in, I don't know if there's anything you want to add, Deanna, or?
No, not so much.
So let's start with the first Supreme Court decision, which came out July 24, 2025, R.V. Kloubakov. I hope I pronounced that right. This is a case that, well, it's the Supreme Court decision on the constitutionality of Canada's, I guess you could call it, anti-prostitution laws, anti-sex worker laws, although that's definitely not the way the law is framed. And it was a big charter challenge to it. The relevance of this, again, to immigration lawyers, consultants, and their clients, the people who are immigrating, is that it will confirm when someone could be inadmissible to Canada for a sex worker related offense. The neutral citation for this case is 2025 SCC 25. In a previous episode that we did with Francis Mahone and Connie, we talked a little bit about how kind of unclear or messy, for lack of better word, Canada's sex worker laws are. Basically, a 2013 Supreme Court decision called R.V. Bedford struck down several sex worker related offenses. And in 2024, Parliament enacted the Protection of Communities and Exploited Persons Act. And it essentially criminalized not the sex worker, but people who profit from it, both financially and enjoyment-wise.
Yeah.
So
anybody who, it was, I think, the first time that it directly criminalized the purchasing of sex, like the payment for sex work.
Yeah. And so this Supreme Court decision upheld the constitutionality of these offenses. So I'm just going to walk through and say what the offenses are so that listeners, audience members can understand what is illegal in Canada when it comes to sex work. So section 286.1 sub 1 of the Criminal Code says that everyone who in any place obtains for consideration or communicates with anyone for the purpose of obtaining for consideration the sexual services of a person is guilty of, and then it's a hybrid offense. And so the relevant of it being a hybrid offense is that it renders someone inadmissible to Canada if they have in any place obtained for consideration or communicated with someone for the purpose of obtaining consideration the sexual services of that person. Consideration
is money.
Is money.
Or payment of some sort. Yeah.
And the other thing that is criminalized, section 286.2 sub 1, every person who receives a financial or material benefit knowing that it is obtained by or derived directly or indirectly from the commission of the offense of procuring sex work that I just described is guilty of an indictable offense and liable to imprisonment for a term of not more than 10 years. So that falls under serious criminality. And the final one, section 286.3, everyone who procures a person to offer or provide sexual services for consideration or for the purpose of facilitating such an offense, recruits, holds, conceals, or harbors a person who offers or provides sexual services for consideration is also guilty of an indictable offense, not for a term of more than 14 years, so also serious crim. And finally, everyone who knowingly advertises an offer to provide sexual services for consideration is also guilty of a hybrid offense.
And
So
you'll
there's
remind me,
specific.
Steve. Yeah, I think that the Bedford case also was about whether or not the current legislative framework as it was at the time, which was before the passage of these provisions, prevented sex workers from actually getting the services that they require to protect themselves,
Yeah,
like hiring bodyguards, hiring drivers. That was what was determined to be unconstitutional in the previous version of this legislation before these changes were made.
yeah. And that's in this decision, the appellants argued that, this idea of material benefit, like if someone gives Tylenol to a sex worker for consideration, are they getting, is that illegal? And the Supreme Court actually addressed it and said no. So some of the clarifications that the Supreme Court gave, individuals selling their own sexual services, whether independently or cooperatively with others, are not subject to criminal prosecution. So again, from an immigration perspective, if you see criminal convictions for sex work, essentially, which is a crime in other jurisdictions. I've certainly seen criminal records that mention it. That's actually not an offense in Canada that would render someone inadmissible. If you see a criminal conviction for purchasing the sex work, that could render someone inadmissible. I only have actually seen this once, and it was in a unique situation in New York where apparently thought like the procedure used to be that if you were caught in a park, as my client was, procuring sex work, you were just issued a ticket. And on the back of the ticket, it said, you now have a criminal record. And the courts in the US struck it down completely. And so we were essentially able to argue that there wasn't a conviction. But presumably, there are also jurisdictions around the world where they don't just issue a ticket and there is a whole criminal charge process. So just be aware again that that would render someone inadmissible to Canada. The Supreme Court did say again that cooperative arrangements among sex workers, where sex workers share costs to lease premise, hire drivers, receptionists, bodyguards, would not be found, would not be a criminal offense in Canada. Similarly, if they hire drivers and things like that, it would be legal as long as the driver, receptionist, etc., does not counsel or encourage such persons to sell sexual services, and provided that the payment or benefit they receive is proportional to the value of the service they provide.
Although in this particular case, this was a driver who was convicted they were working for a commercial operation that was a sex work operation, and they were considered not to be exempt from prosecution because they were receiving the benefit. There's an exemption that's actually carved out. They were receiving the benefit in the context of a commercial enterprise that offers sexual services for consideration. And so their
Mm-hmm.
conviction went forward. And then that's why this allegation was brought, that the exclusion, the fact that the exclusion did not protect those drivers from prosecution, that the allegation here in the charter challenge was that was what made it so that sex workers couldn't effectively protect themselves because they couldn't then rely. They were hoping that they would be exempt because of the fact that these service providers were providing that kind of service on regular terms and conditions, and that they were not that they were not, that they should not be caught by the offense. But what the court said is that because the way that their legislation is written is that if they're working as part of a commercial enterprise, that is essentially that there's like an overall deterrent factor, that there's a deterrent intent with this legislation, which is to try and reduce the reliance on sex work, essentially, that it works from the fundamental premise that sex work is a form of exploitation of women, and that's the objective of the act. And so they kind of took that position in evaluating the constitutional challenge and said that it was not subject to this exemption. And that they were liable for prosecution, and that it was not charter challengeable because it did not meet the requirements. Essentially, it was not a Section 7 violation. They didn't even go on to see whether or not it was proportionate.
And the facts of this case were brutal. Like, I'll just read a paragraph from the judgment, which ML, who is one of the sex workers, testified. I don't even know if that's the right term, but as we read on anyway, ML testified that she met Mr. Proietti in Montreal when she was 17. She had just lost her job, could not pay her bills, and was struggling with drug abuse. She first worked for Mr. Proietti as part of a fraudulent credit card scheme, but she was soon put to work as a sex worker in Saint-Sauveur, Quebec, after Mr. Proietti introduced her to Mr. Marcheterre. She provided sexual services to as many as 12 customers a day, averaging 6 or 7 customers a day, danced nude almost every night, and gave all the money she earned to Mr. Marcheterre. She described feeling disgusted and mentally and physically abused. After about 18 months in Saint-Sauveur, Mr. Marcheterre and Mr. Proietti sent her to work as a sex worker in Calgary because she could make more money for them there. So yeah, I mean, the facts giving rise to this are brutal. But it's also one of those things where the law, like, you read that and you think, obviously, like, that should be a crime, right? It sounds like they essentially forced this person into prostitution, and she was a huge victim and everything. The law itself is much broader and captures a wide-ranging, set of acts. We talked on the last podcast, that I'll link to, with Francis and Connie, about how OnlyFans would work in this context. At the time, you didn't know what OnlyFans was, but there's just a lot of for the purpose of this podcast, to just be aware of what the offenses are, and when they could render someone inadmissible.
I have a question for you, Steve, just in general, because you mentioned the idea of a U.S. conviction. The sort of the way that we were looking at U.S. convictions in the past is that there was a kind of acknowledgement by immigration officers that it was meaningful how the U.S. Criminal justice system had treated a person, whether or not they had decided not to pursue a certain conviction, for example, and they're not using the committing provisions. So now I'm talking about Section 36 of the Act. You can be found inadmissible for being convicted of a certain offense, but you can also be found inadmissible for having committed a certain offense. So, I'm asking this question in the context of where people have, let's say, pled down to a lower offense where it's not driving under the influence, but negligence, something like that, that might not have the same consequences. We used to be able to be quite reliable, that they wouldn't say, okay, well, even though they didn't go for a conviction under this provision, or that they decided to do something that's equivalent to a conditional sentence, we won't use the committing provisions because it's a jurisdiction similar to Canada. We're going to give kind of some weight to how they dealt with it in the US. Do you still feel confident that they will not use the committing provisions in situations like this?
In the context of the DUI being pled down to something like wet reckless or negligent driving, I think that part of the challenge there was often the statute. Even though the heading would change from DUI to wet and reckless, the text would reference that wet and reckless could be caused by being inebriated or intoxicated. So
Mm-hmm.
the plea down, if the pled down offense would still equate to a DUI. I
Mm-hmm.
have only had one instance where somebody was not, I don't remember if the charges were dismissed or they decided not to plead, but where immigration authorities went after someone for the committing an offense provision. And it was
Mm-hmm.
someone who, in their refugee claim in the United States, described all the criminal offenses that they had committed in the United States. And I don't actually remember how that resolved, but it was the only time that I had seen them pursuing someone for the committing an offense
Right.
where the United States had not decided to charge. What is sort of novel now, and what is sort of interesting, at least what I've seen in my practice on one file, is where there's some US jurisdictions, primarily California, which has things like automatic relief. I don't know if you've dealt with this, where someone's
Yeah.
criminal record after a certain period of time, they are automatically, it's sealed or
Yeah.
dismissed. It's similar to a spent conviction in the
Yeah.
United Kingdom. And I'm finding there to be more uncertainty in the Canadian process about whether spent convictions in the UK, automatic relief in California, where a conviction is automatically pardoned, essentially, or in the case of automatic relief in California, it's automatically sealed, what
Mm-hmm.
the immigration implications of that are.
Yeah, I remember hearing someone from IRCC say that they expected the same sort of nature of equivalency with respect to the what causes the offense to become spent. Say, so if it happens just by operation of law, they'll have less interest in that. If it's something that happens through a judgment of the court, then that's something that they would be more inclined to consider because it's more similar to our process in Canada for getting an offense, like a conviction expunged or pardoned.
Mm-hmm.
And so something that just happens like just as a function of time passing, they don't feel compelled to consider that. And I know that that wasn't the way that they always treated the California provisions, but it seems like they even way back then sort of opened the window that that was something that could be done.
Yeah. I remember in the first years of the Trudeau government, there was talk about them introducing something similar where after 5 years, certain offenses would be automatically pardoned. Um, I think Marco Mendicino might have been minister when I had last heard about it because I just remember it being connected to him, but they haven't brought it since. And a regime like that in Canada would be what the immigration implications would be if offenses in Canada were automatically pardoned after a
Mhm.
certain time would be pretty interesting.
You're talking about in the criminal context, not in
In
the
the criminal
immigration context.
context, yeah.
Yeah.
Whether there would be immigration spillovers. So, like for those listening right now, one is eligible to, if one has a criminal record abroad, they can apply for what's called rehabilitation to enter Canada 5 years after the person completes their sentence. And whether they're, and for certain offenses, someone can be automatically deemed 10 years after the completion. And whether or not some sort of an automatic pardon regime in Canada would have corollary immigration implications. I mean, it's very hypothetical. So we'll have to,
Yeah.
yeah.
Shelf
Uh,
that for another day.
yeah. The other Supreme Court decision that came out involved essentially when someone can be tried as a youth versus an adult or sentenced as a youth versus an adult. This is RVIM 2025 SCC 23. I don't have too much to say about the actual facts of the case other than that the Supreme Court made it so that the test, it seemed, was stricter of when a youth could be tried as an adult. But the immigration tie-in is that the Immigration and Refugee Protection Act says that someone who has committed a criminal offense in Canada essentially is inadmissible if it's a hybrid offense, but that someone who is prosecuted under the Youth Criminal Justice Act is exempted. And what I don't think I think that's pretty much common knowledge amongst immigration practitioners. What I think is less common is that that's not the same for foreign offenses. And so if someone is a youth when they're convicted abroad, there's an immigration appeal division decision that gets cited occasionally called Flores Giron v. Canada Public Safety and Emergency Preparedness from 2009, in which the IAD upheld an immigration division decision, which just said that the youth forgiveness, I guess, that appears in the Immigration and Refugee Protection Act is limited to those crimes that are committed in Canada and does not apply to offenses committed abroad. So I think I just, wanted to use that Supreme Court decision to just highlight this case and this issue, which is that youth offenses abroad can still give rise to inadmissibility, even though ironically, if the
If
person
it had
committed the
been
crime in
committed in
Canada,
Canada.
then it wouldn't.
Yeah.
So that's just something I wanted to highlight in this little, I don't know if you have any thoughts on it or.
No, not really.
Yeah.
Yeah.
The other, again, as we just skipped through things, there were two cases that I just wanted to highlight, more just as like news updates for people who might not, follow immigration law news. The first was there was a big immigration case against, I can't remember if he was a consultant or a ghost consultant, who was arrested by CBSA for helping Gurdwaras create fake job offers. And the individual had 12 convictions, or the individual had 12 charges. And during the investigation, some of the witnesses said that they were intimidated by CBSA. And what wound up happening is that all of the charges were stayed because the CBSA process for investigating whether their officer had intimidated witnesses was that that officer would investigate himself. And not surprisingly, the CBSA officer, after investigating himself, determined that he had done no wrong. And so a judge
Imagine that.
set aside the decision and issued a stay saying that, surprise, surprise, investigating yourself results in a complete loss of objectivity and independence of the investigator. So I just thought it's not actually, I mean, it's funny to read, but like the consequences that these charges get stayed, which is good for the accused, but the whole administration of justice takes a big hit.
And the charges were charges of, like, you said it was an
Fake
immigration
jobs.
proceeding or criminal?
No, fake.
Oh,
Oh,
it was a criminal
criminal.
prosecution
Yeah,
against the Gurdwaras or against the.
No, against the, I don't know if it's a ghost consultant or
I
just a
see.
consultant, but
Right.
yeah. The other one that is not immigration related, but I actually just saw this morning, and I thought I really want to hear Deanna's thoughts on this because it goes quite a bit. Peter Edelman, Court of Appeal judge now, spoke at CBA about the decision-making process, and this case just blew my mind, which is that a Hamilton judge was reprimanded and ordered to apologize to someone who was convicted after giving the wrong sentence. And apparently what happened was that an individual who was found guilty of manslaughter, the judge started to read what the sentence would be, and the judge had written in front of him that he was sentencing the person to 6 years, but accidentally said 8, didn't correct himself, and then tried apparently to conceal what had happened. And apparently there was another judge who had said, don't tell anyone about what happened. Somehow it all came to light. And so the Court of Appeal, struck down the sentence, not struck down, just reduced it back to the original 6. But, we talk about like decision making. I almost people will talk about how, before lunch, you're more likely to get a strict sentence.
Mm.
And there's all these little things that you just can't account for, and what's going on behind the scenes and what's going on in people's heads. And the idea that a judge would just accidentally read out the wrong number and then not correct it, and that could lead to the extra 2 years incarceration of an individual is crazy to me.
Mm.
Just crazy.
Yeah. Yeah, I mean, it's not a great time for the administration of justice, I would say, just in general. Yeah, I don't know what more to say really. I think that there, in my like personally, I feel like um, it's been a while now where I feel that I don't have the same sense of faith and comfort in the fairness of proceedings, and I
Yeah.
don't know quite what is causing that climate in general. So um, I don't know. I mean, why did it strike you so much, this one in particular?
Um, I guess in part because it wasn't like I've kind of accepted and am used to the notion that decisions won't reflect what actually led to the decision, right? We've talked about
Hmm.
this ad nauseum
Yeah.
on this podcast. Actually, I mean, a big non-criminal update in the immigration world is that IRCC announced that starting immediately for all temporary residence refusals, that they would be providing the internal notes at the time of the refusal. And
Yeah.
for a few minutes, everyone thought, oh, this is great. There's going to be so much more transparency in the process. I actually, well, I actually predicted what would happen, which is that a few minutes later, once those refusals started going out, people would say, what? This is just almost as vague because they're Chinook, right? They're Chinook refusals. So
Hmm.
people are saying, what? This is just as vague as this is barely any better than what's in the bullet point refusal lists. And I've been used to the notion that refusal reasons will be vague, that decisions won't be clear. But the notion that a judge, who I guess I do hold to a higher standard, would have a verbal slip and then just not correct it, leading to a further 2 years of imprisonment, so seems to exceed. Like there's no, I can accept that the immigration system for speed and efficiency is going to put out these. I mean, I can just accept the rationale, right? There's speed, efficiency. They're going to put out. They're using bulk refusal software. It's going to suck. But I would like to think that when someone's just reading a decision, and if they have a verbal mistake, that
They can
they would
eat it
just
and
correct
just,
it, right? Like just
yeah,
be like, oh,
exactly.
I said the wrong number. Like the comparison in an immigration decision would be, say, if you're at a detention review where someone lists and gives all the reasons, and you're like, oh, they're going to be released, and then the judge or the member goes and detained,
Yeah.
and they later were like, oh, I actually went to release, but whatever, they're detained now. I'm not going to like bother just correcting. Like it's at such a different level to me that it's disturbing, because then you also wonder what else goes on that like we don't know about. I can't assume that this is common,
No.
but I have no
Uh,
idea how often it does it. I mean, it's just so bizarre.
yeah. I embrace the very common perception that I am a person who's naive and idealistic. I know that these are qualities of myself, but when I hear things like at the immigration conference when we were talking a lot about artificial intelligence,
Mm,
the department was talking about how they approach the advent of technology, and they talked about the fact that at the very outset, when they were like, okay, what are we going to do? The first project that they undertook was one that it was the development of a platform called something like the little litigation support services platform, which was designed to predict the outcomes in federal court jurisprudence. And to me, it fortified what I had always believed, is that the kind of creation of reasons that will be JR proof, that it's not
Yeah.
necessarily in any way a reflection of the actual reason why somebody was refused, but just rather reasons that are crafted to withstand judicial scrutiny. It, to me, at that point, I was like, okay, well, actually, there's nothing that ties the written reasons to the actual. I was talking to somebody yesterday who was a relatively young person wanting to be able to have a visit from his girlfriend who lives abroad, and it's like, I just want to be able to have this visit, what can I do? And when you sort of are you see behind the machine, that,
Hmm.
like, essentially, um, in these circumstances, there's always going to be a reason that can be crafted that might be able to withstand judicial scrutiny. And what we have seen as litigators is that even if it can't, they don't really seem to mind. Like, what we're seeing now in those written reasons, we have all read 5, 10, 15 decisions that have said, nope, that is not okay. And then it's just waiting for the algorithm to adjust and no longer put those specific words into the reason. It will sort of like filter through, and then we'll stop seeing those words. But again, it's like the artifice
Hmm.
behind this process has become so clear to me that it takes a lot to surprise me now. So I
Yeah, it's really
understand this one
interesting
is
with the
like,
reasons. Like I used to always say that the reason that IRCC didn't provide those notes was because a lot of the times the notes are unreasonable. And so let's just say that 25%, these are made up numbers, but let's just say that 25% of IRCC written internal reasons are unreasonable. And there's 100 people refused. And the only way to get those reasons is through judicial review or an ATIP. That's going to weed out, say 90% of people from challenging a refusal. So 25% of people who see that, you get two-ish people who are now challenging decisions because they just don't know what the internal reasons are. If those are public upfront, as they're doing now, then you will have 25% of people going, what the? These reasons make no sense. Probably even worse now because of Chinook. And
yeah.
so the potential for sure there's going to be pressure to get better reasons, whether because otherwise the litigation, like the federal court's about to get hit with another wave of more and more litigation because people see upfront how unreasonable the decisions are and that they are much more likely to win. That will either lead to just an increase on burden on the federal court or some movement to or effort to increase the quality of the decisions themselves.
I'm not really sure it's about the decisions. I mean, really, I think for the most part, the reason right now that there's such a large number of refusals is because of the 5% commitment. It's just, the answer is that when there's a doubt, there's no doubt. Like, if they think that there's any risk that the person will not return at the end of the period authorized for their stay, they say, no, we've got 5%, and this is not one of those cases. It's really, they're just trying to make sure that they're in compliance with that quota. And so,
No, but the
so
reasons, like with the letters, like they will face, if they don't do something to increase the quality of these decisions beyond what Chinook provides, this bulk
mhm.
processing where things are dumbed down to the late, like how many people can be captured in a refusal sentence, regardless of whether it applies to the person. There will be such a dramatic increase in litigation that
For sure.
it'll
But it
either
just
just
kind of,
add to the backlogs or lead to some sort of change.
but if there's more than 5% of the population who's going to make a legitimate temporary residence application, but they still don't want to approve them because they want to be able to hit that target, they're going to be refusals that are, either they issue a bad refusal or they don't meet their target. And so, it's, do you know what I'm saying?
Yeah, I don't know. I mean, I know they're like, I still find that
I feel like they're just kind of doing
post-judicial
it with
review
impunity. They're
success
like,
rates. No, I mean, I
yeah,
still find that post-judicial review success rates are pretty high. So I don't know. We'll see. It's still very
yeah.
early in this. It's only
You've
been a
not been on
day
the
or
merry-go-round
two.
yourself?
I actually have not been on the, I'm trying to think now. The only time the merry-go-round has sort of arisen is when like the passage of time has led to eligibility issues. Like if someone had applied for an open spousal work permit as a student, and by the time the judicial review is done, the person's graduated, there have been some issues in trying to get it switched to now open spouse as a worker. But otherwise, I haven't. I'm not denying the merry-go-round exists because like I've heard enough stories and that like I luckily I haven't seemed to have experienced it yet, knock on wood. But
Yeah,
yeah, like so I mean we'll see. I
yeah,
just it's funny, like at a time when the federal court has implemented these measures to try to reduce in part the administrative volume that's falling on it, the release of these internal reasons up front, I think, is going to lead to a dramatic increase in judicial review because people will
yeah.
see
That they're
right
patently
away how
unreasonable.
unreasonable
Yeah,
it is.
yeah, yeah,
Um,
yeah, I
yeah,
agree.
I mean, even right now on LinkedIn, people who are posting these are commenting with disbelief. What? This can't be the full set of internal reasons. They're not
Yeah,
showing it all, and I'm like, no, no, it's just that bad right now.
yeah,
Like,
it's just that bad. Yeah, no, that's absolutely true. I think we're in a way dealing with two separate issues. One is about the quality of reasons, and the other is about the persistence of the no.
yeah,
Um, and so they're both big issues, and I don't think we have answers to either of them. But I finally just got an approval after a two-time JR, and so third time was the charm, and so we finally got a passport request. But um, when you think about mapping that sort of a situation in the present timelines, given how many years it's taking to reach the
hmm
court, it's going to take very tenacious litigants to actually get to that point.
yeah. The last topic. Well, I was going to joke about how bike lanes in Toronto have more charter protection than immigrants, but that might be a topic for another day. Is
Mm,
so just something that like I don't want to get too political, but it's it's been interesting watching as Mark Carney takes the federal government to the right, what the Conservative Party is choosing to focus on.
mm,
And one of the things that they seem to be have decided could be one of their issues is immigration. So I'll just pull up Pierre Poilievre's tweet at the start of the month, and the liberals or the conservative ministers have sort of been on this, which is that through an ATIP, thousands of foreigners with criminal convictions were forgiven by Ottawa over an 11-year span, raising transparency concerns. And Pierre Poilievre tweeted, "This is nuts. Liberals deliberately act to let criminals into the country. They are irresponsible and will never fix what they broke. We need an immigration policy that puts Canada first, our safety and security." To which I had then tweeted, in 2013 when the Conservatives were in power, CIC issued, and then I just posted all the stats on temporary resident permits for people who are criminally inadmissible. And what really just drives me nuts, and what I think we can close out today with, is just kind of your thoughts on this sudden notion that Canada is letting in thousands of criminals and that this means that our immigration system is broken. And maybe do you want to give an example of some of the like examples of criminals in quote that you've successfully gotten rehabilitation applications for to show just how broad some of the offenses can be. Let's
I
set
don't
aside
do.
the hypocrisy of like the law on rehabilitation is the exact same under the liberals as it was under the conservatives. There
Yeah,
did seem to be, a bit of a Maud Flanders. Won't somebody please think of the children with the notion that Canada is just the safe haven country for criminals that the liberals are letting in?
yeah. Um, I don't do a ton of rehab applications. I've definitely done my fair share of them over the years, but um, a lot of them have been like 20, 30-year-old convictions, where, you know, like even where it's something where like we talked about driving under the influence type charges, often, or sometimes they're like minor like assault type charges, but I found in the past that it's often in situations where the person was struggling with an addiction issue, or was going through depression, or was struggling with post-traumatic distress, for which they have since received treatment, and they have had like a complete life turnaround. And that because of that offense that was 10, 15, 20 years ago, that they need to apply for rehabilitation. So you know, I don't know if you probably do more of these than I do, Steve.
Oh, I do a fair bit, not as much as, I mean, the overwhelming majority of people who seem to be caught by this are Americans.
Yeah, for sure.
And I would actually imagine that there was a lot more forgiveness under the conservatives than under the liberals, if only because since COVID, cross-border travel is so much reduced. But to give an idea of like the type of crimes that we've had to do rehabilitation applications for, the one that always comes to mind is that we had to act for someone who was denied entry to Canada because 7 years prior, he was driving his boat in Alaska and there was mud on the license plate. And he got charged and convicted in Alaska for that. And CBSA rightly determined that that constituted an offense under the Fisheries Act, which provides that license plates have to be clear. And the Fisheries Act provides that any contravention of the Fisheries Act or its regulations is a hybrid offense. So this guy would be one of those people who was a criminal let into the country because 7 years prior he had mud on his license plate. And there's several of these for, I mean, the other one, yeah, I mean, there's just the main one, which is serious, is DUI, and I don't know how long that should haunt someone.
Yeah.
But again,
Yeah,
like
it's
that's a
hard when you get
lifetime bar.
somebody, yeah,
Yeah.
yeah,
So like
who
a 30,
something that they
40
did
year
is
old
a,
DUI,
yeah,
theft from when someone was like youth, essentially, like 18, 19. Actually, one that we did was someone who was in his 50s and he had, when he was 18, crawled into, you know, those like ceilings. I'm looking at one right now in my office where you like they have the panels that you can
yeah,
push aside. He crawled in there, waited for this laundromat to close that he was in. When the till came or when the store closed, he snuck out of the ceiling, smashed a till, served or stole $75, wound up going to jail for 3 years in the strictest state. Don't ever do that in Indiana. And 20 years later, he like needed, or 30 years, he needed a rehabilitation application.
yeah,
So I just don't buy this notion that anyone who's gone through the rehabilitation process, it's not a smooth process. You have to gather a ton of documentation. CBSA takes it very seriously. IRCC takes it very seriously.
it's by no
And I
means a
just,
lax process. Yeah,
yeah, it's not a lax process. And I don't accept that. Ignore for a second the whole Conrad Black getting a TRP when he was still in jail when the conservatives were in power. I just don't buy that the like I don't buy for a second that Canada is this country that is soft on letting criminals in, and B, that it was any different under the conservatives than it is now.
yeah, yeah. It's not been the area of the focus of my practice for sure. I'm much more on the medical misrep. Those are the kind of admissibility admissibilities that I've spent more time focusing on, um, but but by no means have I found it a cakewalk. And also, I think that a lot of it, like when you're making a TRPA application, you have to balance the severity of the offense, the proof of rehabilitation, all of that sort of thing against what is the need. And so if you're just wanting to come and go skiing, that's not by any means as compelling as if you're wanting to reunite with a family member or a spouse or a child who lives here in Canada and is a permanent resident or a citizen. So, so again, I think taken out of context, it seems like, but I think considering the harshness of penalties.
Yeah. On TRPs and misrep, you know, with someone can't apply for criminal rehabilitation until 5 years have passed since the completion of the sentence, although they can still do a TRP. It's not that dissimilar to the misrep of 5-year bar on entering Canada unless you get ARC or a TRP. What do you find or have heard of the general success rate for TRPs or ARC during that 5-year period?
It's not great.
Yeah.
Not great at all. And in fact, a lot of the time, even after the 5-year ban has completed, trying to get back into Canada on a temporary basis is super challenging.
Yeah.
That was one of my merry-go-round JRs. It took us 3 times to get a TRV
Oof.
issued after the 5-year ban had expired. And again, one of the arguments that we made quite persuasively, I hope, was that it's not a lifetime ban, and but again, it's very hard to get at in the reasons why somebody is still considered to be an overstay risk, because that's how the reasons were written, because the ban had expired. But it did, people say, is this going to hurt my record forever? um I this was an application for a TRV that was like an exceptionally strong TRV application, but it was refused repeatedly after a 5-year ban had expired. So I felt like it was very hard to get at what the real reason was for refusal, because it certainly wasn't financial. It certainly wasn't lack of
Yeah.
assets. It certainly was not lack of travel history. $100,000 more in the person's bank account, huge business interests in the country of citizenship, traveled all around the world without incident. And this was a misrepresentation, like by failing to mention that they had refused US
Yeah.
visitor visa application. So yeah, it's
The
real.
hidden, again, it goes to what we were talking about before, the hidden reasons.
Yeah, the hidden
Yeah.
reasons. Yeah, and the kind of like the culpability. Like I think that they might not say it in the reasons, but I feel like this kind of overwhelming sense that that they can't be trusted, I think does seem to can continue for a real long time after.
Yeah. Let's go to listener questions. We have one, which is the same type of question, not that we don't mind it, that always sees a comprehensive ranking score of 514 points. What are the odds that this person is going to get an invitation to apply?
Well, so I mean, we do talk about this one. I think it's a question that we see on most episodes. My personal thought is that I don't see the CEC, I don't see the scores coming down unless there's a fundamental shift in policy.
Yeah, I don't see it as well. I've become more pessimistic as the year went on. Actually, one of our more popular episodes was with Christopher Warwick, on the economics of removing 1 to 2 million people from Canada. And if we accept, to the extent that we do accept, that this is a political decision based on economics, there's nothing to suggest that Canada's economic situation will improve enough that will give the government enough confidence to start increasing immigration levels. And indeed, Mark Carney ran on this platform of keeping immigration tight essentially till 2027. I think now they're doing consultations for what will happen after 2027. The counter argument would be that with less students and foreign workers being eligible, being here in theory. If 1 to 2 million people do leave, there will be less people in the pool. The thing, though, is with the reduction of arranged employment points, you just need that you don't need to be actively working in Canada to get Canadian experience. So even if you're now lost your work permit, you're a visitor, or you're not even in the country, until
You
some
remain
time
in
has
the
passed,
pool.
you still have the same amount of points and you
Yeah,
remain in the pool. So I think it will unfortunately be difficult. I don't want to say
yeah,
don't have any hope, but keep your hope in check.
yeah, for sure. Managing client expectations has become a major part of the job right now, unfortunately.
Hmm. It's, I mean, yeah, I was chatting with some people who even wanted to do an H&C application yesterday, and they said, "Oh, it seems like, 2 years. Is that what it's going to take?" And I'm like, well, bear in mind that here's the backlog, and the targets are supposed to go down 60% for admissions. So
Yeah.
I
No,
think
I mean,
across
this
the
is
board.
like we did do an episode specifically on H&Cs, but I'm getting a huge volume of people almost daily asking me about applying for humanitarian and compassionate grounds. And I mean, one thing I just want to say, generally speaking, is that the government has made absolutely clear that the humanitarian and compassionate pathway is not supposed to be its own kind of immigration class. Now, it's hard to understand what that means because it is actually its own immigration class. But however, I think that in a situation where there's just hardship faced generally about not being able to remain in Canada, um, I, I don't think that those in general are going to get a lot of priority, or they're dealing with a lot of people applying in this category, and so they need something truly exceptional.
Yeah, here's a comment that we got on Instagram that I'm just curious to hear your thoughts. The full question, I couldn't type it all out, and the software that we're using doesn't transfer Instagram that neatly. Is Canadian PR going to be a dream for many? I spent my 5 years in Canada and now ended up in India. What's the mistake I did? Maybe not choosing the asylum seekers way or refugees. So I think that people who claim asylum do have to show persecution. There is some resentment building up sort of to the increase in asylum claims at a time when regular, for lack of a better word, regular pathways are closed. Do you want to maybe just speak to that quick?
Yeah, I mean, I would say there's no more difficult pathway than the refugee pathway. So this idea that that would have been the save all, I think, is a false premise, because I only advise and recommend making a refugee claim when the fear of persecution is so severe, and it's something that I think can be, sorry, um, credibly proven on evidence. I think that there has unfortunately been a lot of people advising, yes, this is a viable refugee claim, when in fact it's not something that is going to meet the very high bar of proving persecution. It's not just subjective fear, it's that there's, objectively speaking, sufficient evidence to show that the person would not be able to avail of the protection that their own country is able to offer. Um, and it's not just generalized risk that everyone in the country is facing. So Canada's receptivity to asylum claims is low, and even hugely well documented claims from countries that are have a very bad record in terms of human rights compliance. Those claims, even them, they are very difficult to actually succeed with. So I don't want anyone to walk away thinking that, yes, if I just file an asylum claim, then I'll be good. I very, very specifically curate the refugee claims that I bring forward, because they're very, very difficult. But in terms of your question about, is PR going to be just a dream, and I think my very honest, but also very harsh for some people answer is that yes, for some it will just be a dream. And I think I find that more than ever, that's what I spend a lot of time saying to people that people keep asking me, so what can I do here now? What is my option? And, just trying to make clear that immigration has made a very specific and deliberate choice to close this avenue for many people. And whether you and I disagree with it, that is the reality. And I don't think you did anything wrong.
Mm-hmm. Comments are starting to come in fast and furious. We have Totini, who says that the famous line of Mr. Kubir, be forever hopeful. We're both Kubir fans. He's been on the podcast. We've been on his podcast. I would say that be forever hopeful can be viewed as, just being optimistic, or that because it's never working out, you just have to keep hoping. And so which it ultimately will be is
I definitely am
hopefully
of
it's
the
the former
optimistic
that you're
camp.
optimistic and not just that you always have to hope because you've never gotten it. But
Yeah, I definitely believe in optimism and the power of positive thinking and all of that sort of thing. But at the same time, I feel like I don't want to send people down a rabbit hole that I think is not viable. And I certainly don't want to encourage people to make claims or file applications that don't have a chance of success. I would rather people say, like, okay, well, this is actually the reality, and I would like to make some informed choices on that basis.
yeah.
But definitely with hope.
Any hopes for a trade draw in express entry? That could also be, are there any hopes for, so there's two types of trade draws. There's the federal skilled trades class, which I don't think has had a draw since at least possibly since the Liberals assumed office. Like it's been, I don't even know like why that program still exists because it seems to have been forgotten about. There also are trades categories within express entry. And I think at some point, I think you should have more. I think it's reasonable to hope that there will be a trades draw at some point.
I don't know enough about that one. I'm going to refrain from commenting.
Yeah. I just feel like if the category exists and they made all this fanfare about creating it, that they'll likely do a draw under it. But again, what the points will be, when it will be, is less clear.
I just
I
don't
don't.
get why, like, all this stuff about not like housing and all that. Whenever I talk to somebody who runs a construction company, they talk about labor shortages, but I just don't get the disconnect.
Yeah. This one's a bit specific, but I've just encouraged the person to just double check online rather than listening to us necessarily, as we don't want to be giving legal advice on the podcast, which is I'm a Canadian citizen and I'm studying in the United States. I got a ITA in the parent and grandparent program. Is it possible for me to apply? I don't really want to answer that just because I feel like I know the answer, but I don't want you to rely on it. What I will say is that this question is interesting because when this person applied and submitted the expression of interest to sponsor their parents would have been 5 years ago because IRCC is still doing lotteries for the people who submitted their expressions of interest in 2020 and haven't let new people in. IRCC also, I don't remember the exact numbers, but it was something like they issued, I think, 20,000 invitations to apply or 17,000. And they said our hope is to accept about 10,000 or so into process. It was some number where like basically they are expecting or planning on 40% of people who got expressions of interest to either not apply or for them to cancel their applications. So just something to watch out for there.
What I would say is you definitely need legal advice because I do believe that there is an exclusion when you're no longer residing in Canada. And again, this is like, catching us off guard. So, but I do think that there may very well be an exclusion if you're no longer in Canada.
Don't take
So
legal advice from an off the cuff podcast.
exactly. That's right. But get legal advice is what I'm saying
Yeah.
here. But it's one of the challenges of there being such a long delay between people entering the pool and people getting the invitations.
Yeah.
And also Steve has posted about this, which is that they are really assessing these PGP applications with a lot of scrutiny. So
yeah, resume. If you do
beware.
sponsor, the resume is not a resume. It's a list of their whole personal history.
It's a Schedule A form.
Yeah, Mohit says IRCC should start at least giving out PGWP, postgraduate work permit extensions like they do in H-1B. They did do PGWP extensions around 2023. They extended a lot of them by 18 months, but as Deanna was alluding to, there's a 5% target of foreign workers or foreign nationals, study permit holders and work permit holders in Canada by 2027. They will not hit the targets if they issue PGWP extensions. So I would not bank on PGWP extensions. Again, the goal of IRCC right now under the 2025-2027 immigration levels plan is to reduce the population. Last one from Daria Canada Immigration is that I hope that IRCC changes this approach of selecting candidates from 2020 only. I think a lot of people would like that for new
Join
people
the
to
club
enter
for
that
sure.
pool.
Yeah.
I'm surprised they still have people. Like, imagine you're in this lottery for 5 years and you still haven't gotten drawn yet.
Yeah.
What that must be like. But
to me, this is a PR stunt.
yeah, whole thing is a bit ridiculous.
It is
That is
ridiculous.
it. I thought it would be short. We went the full hour. Thanks for all
Yeah.
the questions. It's always, while we don't like while we can't answer off the cuff legal advice questions, we're happy to receive them and give
and
at
say,
least
yes,
thoughts
this is
on the
something you should get
policy
advice
behind,
about.
or yeah, exactly. So thanks everyone, and we'll see you next week.
Then.